Employees are treating AI like it's their private diary, which it is not. Their conversations with AI platforms should be treated like it will be read out loud one day and not just anyone's deposition, your deposition. So it's very important for clients to be educating employees on using AI platforms responsibly.
Welcome to AI Council Code. I'm your host, Maggie Welsh, and today we're going to focus on the intersection of artificial intelligence and litigation, how new AI tools are shaping legal strategy, risk, and decision making inside and outside the courtroom. I'm pleased to be joined by my colleague, Ariel House, a partner at Baker Botts, with deep experience advising clients on complex litigation and emerging technologies. So stay tuned for some interesting insights.
Baker Botts, LLP, provides podcasts for educational purposes only. They are not legal advice and are not intended to establish an attorney client relationship. This communication may constitute attorney advertising.
Ariel, thanks for being here today. And why don't you introduce yourselves to our listeners?
Hi, Maggie. Thanks so much for having me today. This is actually my first time on a podcast. I've been listening to our podcast for a while, so I'm excited to finally have the opportunity to join you. My name is Ariel House. I'm a litigation partner at Baker Botts in the Austin office. I'm licensed to practice both in California and in Texas. I actually originally started in Baker Botts' San Francisco office and was there for the first few years of my career with the firm, and then have been in Austin for the past six. And I actually just celebrated my 10-year anniversary with Baker Botts last month, which is an exciting milestone. But my practice involves complex commercial litigation and intellectual property litigation, specifically trade secrets, copyright, trademark cases, and matters similar to that. I usually practice all over the country in all kinds of different state and federal and appellate courts and represent a pretty wide range of clients from really large companies to some small startups that are based here in Austin that we get referrals from.
Thanks, Ariel. Thanks for being with us, and congratulations on your 10-year anniversary, a nice milestone. So, at a high level, everyone has questions about AI, and the question we receive a lot is AI fundamentally changing litigation and how we think about work product and attorney client privilege? Or is it really an exercise in fitting AI and the AI tools into the legal framework that we already have?
From my perspective, AI certainly involves a bit of a shift in the sense of how we're used to thinking about concepts like attorney client privilege and work product. To answer that, let me start with some of the basics about those concepts, such as work product. And then we can talk about how the new AI generated materials fit into that framework. So, historically, work product protection attaches to materials that are prepared in anticipation of litigation or for trial, generally by or for an attorney. Each state has some version of a law protecting work product, many of which mirror the standard that's set forth in Federal Rule of Civil Procedure 26B3, which makes clear that ordinarily work product materials are not discoverable unless a party can show there's a substantial need for those materials and without undue hardship, it cannot obtain their substantial equivalent by other means. But one thing that I think is really important to keep in mind is that historically there have been kind of two different levels of work product protection. The first is a higher level of work product protection attaches to an attorney's private thoughts, legal strategies, mental impressions, and opinions. That layer is very carefully protected by courts. It's very difficult to ever be able to compel the disclosure of such materials during discovery, even if the other party can make the requisite showing of a substantial need for those materials. It's very likely that they would be heavily redacted and would still protect the attorney's mental impressions and strategies. But there's also kind of a lower level of work product protection, which attaches to what's called fact worked product or ordinary work product. And generally, that kind of information can be discoverable if the party seeking that can demonstrate a substantial need for those specific materials and show that they would suffer an undue hardship in trying to obtain that information by any other means. The reason I mentioned these two different levels of work product protection is because we're finally, over the past few months, starting to see a few courts grapple with some litigated disputes, specifically involving alleged waivers of either attorney client or work product protection in ongoing litigation matters. But most of those have involved what's typically been considered the second less protected form of work product protection. I think that's an important distinction to keep in mind as we're considering this issue. To loop back to your original question, my view is that the use of AI in litigation doesn't necessarily involve a fundamental change in how we think about concepts like work product protection and attorney client privilege. The same rules and framework we've always used to evaluate a party claiming those protections and a party challenging those protections can be applied to a litigant's use of AI. But we're certainly seeing the use of AI testing those concepts in some unprecedented ways.
Interesting how you framed it into the two levels of work product, that higher level and the lower level, where some of the courts are addressing that today. So let's talk about those specific decisions that we've seen in the news, and how have courts started to consider work product protection? What approaches have they been taking on those issues?
Right now, this is obviously a fairly novel issue. So there haven't been a lot of court decisions that have come out on this yet, and courts have not yet had the opportunity to start coalescing around a common approach to those decisions. There's three main ones in particular that have come out over the past few months. The first one I'll talk about today seems to have gotten the most attention, and that's US versus Hepner, which was a case in the Southern District of New York that was decided in February of 2026. In that case, the court held that a criminal defendant's conversations with a publicly available non enterprise generative AI platform that were not made at the request of counsel were not protected by the work product doctrine or attorney client privilege. Maybe because this was one of the first court rulings to address this issue and it involved a decision that was fully unprotected, that decision has gotten a lot of attention. I've seen a lot of commentary that folks are very anxious that using the AI means you're going to be waiving privilege. Sometimes, yes, that will be true. But to me, Hepner is a pretty limited decision involving some very specific facts. And I think if you think about that fact pattern in analogous ways, instead of just focusing on the AI piece, I wouldn't think that a criminal defendant's Google search history would necessarily be protected either. I would think that's probably discoverable. Similarly, if a criminal defendant had a conversation with a non attorney about the charges that were being brought against him, I would also think that non attorney could be called to testify about that conversation and it wouldn't be subject to any kind of privilege either. So to me, Hepner is a pretty specific decision limited to those facts that doesn't necessarily have these broad implications for wholesale privilege waivers that folks seem to be attributing to it. There's been a more recent decision that came out at the very end of March from the District of Colorado, which is Morgan versus F2X Inc. To me, that's a bit of a more interesting decision that I think is going to be followed and is going to involve issues that are going to come up more frequently, at least for me in my practice as a civil attorney, than what we saw in Hepner. In the Morgan case, there were three different aspects of the court's ruling that I personally feel is the direction we're going to see more courts coalescing around in the future. The first is that in that case, the court held that a pro se litigant's use of AI in litigation preparation was entitled to work product protection under Federal Rule of Civil Procedure 26B3. That makes sense. Work product protection should also apply to pro se litigants. It is intended to cover materials prepared in anticipation of litigation by a party or their representative, right? The court notably considered the Hepner decision, which had been decided before, and found that Hepner was distinguishable because Hepner was a criminal case, while Morgan is a civil case governed by Rule 26b3, which broadly protects the work product of a party, not just his or her attorneys. And the court also found that Hepner was distinguishable because the AI conversations between the criminal defendant there and the AI platform were done entirely on his own, apart from any interactions with attorneys. Whereas Morgan involved a situation where the litigant is both the party and essentially the attorney advocate. The court also concluded that putting information into a public AI tool does not waive work product protection because of its view that AI is a tool, not a person. So its work product protection is not waived by that disclosure. Second, the court found that work product protection did not extend to the disclosure of the identity of the AI tool that was being used by the litigant. The court found that specific piece of information was discoverable and the other party was entitled to that information in order to be able to more fully evaluate the contours of their claim of privilege. Third, the court also addressed how the parties' protective order should be revised to address their use of AI. And the court decided to add a new provision that would prohibit any party from inputting any information designated as confidential by the parties during the discovery process into an AI platform unless the provider is contractually prohibited from storing or using inputs for training and from disclosing inputs to third parties unless that was essential to the service delivery. Now, the court acknowledged that a provision like that would likely prevent pro se litigants and others from using most free AI platforms, and they would necessarily be restricted to the more costly enterprise AI platforms in the future.
The one thing I want to pull out from your overview is with respect to the work product protection. Is a court effectively saying that AI is a new participant in the communications?
The prevailing sense under the law, at least in this country, has been more of the view that AI platforms are technological tools and not persons. That's come up in a few different contexts. One example is the current limits on AI generated materials generally not being copyrightable because they lack the human authorship requirement. Now, if we turn to the litigation context, which we've been discussing, to the extent courts have grappled with this issue, they have taken the approach that AI is not a participant or a kind of third party to those conversations, but merely a technological tool. That's what we saw the court decide in the Morgan case. And specifically in the Morgan case, that court relied on another recent decision, which is Warner versus Gilbarco from the Eastern District of Michigan, which similarly held that materials prepared by a pro se litigant were protected by work product. And in both Morgan and Warner, the court said generative AI platforms are tools, not persons. In the Warner case, the court wrote that if simply uploading information onto an AI platform could waive protection, then it expressed concerns that this would nullify work product protection in nearly every modern drafting environment, which certainly is a result that no one would want. So, generally, the approach has been more that AI is merely a technological tool and not a third person, a third party, another participant.
And so just by disclosing information to AI, it's not automatically waiving attorney-client privilege or work product protection. There's more nuances and facts that need to be considered. Is that generally right?
There's always more nuances and facts that need to be considered. Some of those involve considerations of things like whether it's a public AI platform or a private, more secure enterprise platform. In the future, it is going to be a little harder to claim protection over public platforms in certain circumstances and a little easier to make those claims with respect to private enterprise versions. Obviously, the timing of when those conversations take place, if they can be linked back to ongoing litigation, discussions with counsel, that kind of thing. We're going to see a lot of those different factors come into play to either strengthen or weaken assertions of attorney client privilege over those and work product protection over those.
And going back to the Morgan case, you mentioned that the judge revised the parties' protective order to address their use of AI. So, what role are you seeing protective orders playing in litigation for regulating the use of AI?
I can tell you that in all of my cases, every protective order that we are entering from now on is going to specifically address the use of AI in litigation. I expect that to become part of the standard format of protective orders moving forward. A lot of courts have, and a lot of judges have their kind of standard format, protective order, ESI order, that kind of thing on their website. I expect more of those standard templates to start adopting AI use provisions as well. But personally, on my cases, the approach I've been taking and advising my clients to take is similar to how the court addressed that issue in the Morgan case. You can, of course, draft language in different ways, but the main goals for me when it comes to addressing AI use in litigation in the future are to number one, prohibit any party from disclosing materials that are designated as confidential or highly confidential into any public AI platform, limiting the use of those materials to only closed or enterprise grade systems that have more robust privacy and security controls. And then, second, making sure that any AI tool that's being used by anyone for litigation purposes involves contractual guarantees that number one, it will not use that data to train or improve its machine learning models or algorithms. And number two, it has the capability to permanently remove any protected materials upon request, which could take place at the conclusion of litigation. So I'm trying to make sure that all of our protective orders have provisions like that moving forward. A lot of firms and companies have different systems they're using. The enterprise systems tend to be a little more secure. We're trying to balance the reality that a lot of folks are using AI for work purposes these days with the need to still make sure that any material I have to produce that involves my client's confidential information, that information is going to remain protected despite the fact that we have to produce it in litigation.
And let's talk about discovery and producing material in litigation. What should counsel be thinking about in terms of discoverability of AI generated materials?
The approach we're generally seeing is that using AI tools for work purposes is being considered to be yet another new source of discoverable information. And sometimes it seems that the ESI obligations are never ending, but the same is true of these AI platforms. So that means that AI platforms need to be preserved, they need to be subjected to a litigation hold, and they need to be collected just like all other sources of electronically stored information that could have information relevant to a lawsuit or threatened lawsuit. We could liken it to other developments we've seen in the past over the past several years using chat services like Microsoft Teams and Slack became a lot more popular and incorporated to a lot more work streams across different companies. And after that happened, when we started doing litigation holds and ESI collections, we have to talk to our clients about whether they use any of those services. We have to collect and produce all those conversations in litigation, in addition to emails and like occasionally cell phones and all other kinds of ESI. So, to me, using AI is the latest extension of ESI obligations. It's a source of information that may be relevant to a lawsuit that's pretty involved. To me, using AI is just the latest iteration of a technological development that has created this new source of information that is going to have to be collected and preserved and may contain information relevant to a lawsuit in the future.
And if you had to give clients one or two practical rules to manage AI related litigation risks today, what would that be?
I probably have more than one or two that people could follow up with me after this podcast about that. I just mentioned when we started doing more collections from Microsoft Teams, Slack, GChat, things like that. One thing that I learned very quickly is that employees tend to talk much more informally over that medium for some reason than they would over their work email. Depending on who you represent in the litigation and what was said, that could be either a good or bad thing. My initial early impression of what I've been seeing so far from our clients and their employees and their AI use is that is an even bigger issue when it comes to using AI. People are treating AI, even if they're using it for work purposes, like it's their private diary, which it is not. One thing that I think is important to get across, and we'd be happy to come and provide trainings about these best practices for advising your employees about using AI in light of the fact that this is probably going to be something that needs to be collected and preserved for future litigation matters. It's an important thing to educate your employees on. Their prompts, their conversations with AI platforms should be treated just like their work email. We like to use the old adage about dance like no one's watching and draft an email like it will be read out loud one day in a deposition. Not just anyone's deposition, your deposition. So it's very important for our clients to be educating employees on using AI platforms responsibly and being aware of the fact that communications with AI platforms that are not prepared at the direction of counsel may not be protected by work product or attorney client privilege. I consider that to be a potential headache moving forward. Another is making sure that folks understand that AI platforms are, in fact, likely to be a discoverable source of information that need to be subjected to litigation holds and collected. A third issue that I know a lot of clients are concerned about involves their employees' use of what's called shadow AI or using an AI platform for work purposes that may not be their employer's authorized AI platform. That can create all kinds of problems from a litigation perspective in terms of what needs to be preserved, what needs to be collected, what is going to be protectable or not, what is or is not going to be confidential, etc. So that's another big concern, and that's also something we're happy to talk to folks about in terms of best practices they can employ about trying to get their employees to identify all AI platforms they're using, focus on using the authorized ones, that kind of thing. Lastly, I'm always going to be concerned about how the other side may be using and regarding my clients' confidential information that we have produced during discovery. But I think for the most part, those concerns can largely be addressed by drafting appropriate protective orders, like we talked about earlier.
Great. Thanks, Ariel. And thanks for being with us today. And thanks to our listeners for listening to AI Council Code. We're so glad that you joined us. Stay tuned for additional podcasts and more insights on AI legal issues from Baker Botts.
Thank you for listening to this Baker Botts podcast. Baker Botts has the experience, knowledge, and people to address our clients' most significant legal issues. For more information on Baker Botts practices, please visit us at bakerbots.com. This presentation is provided by Baker Botts LLP for educational and informational purposes only. It is not legal advice and is not intended to establish an attorney-client relationship. Under the rules of certain jurisdictions, this communication may constitute attorney advertising.